when the other party refuses to divorce, that is worse than criminal defense. It's worse than death penalty cases. Because you have another person who knows everything about you and expose everything under the sun in the court. Who knows you more than your spouse who you've been living for the past 10 years. They know you more than your parents. Because when they prosecute you for death penalty cases, they may not know 100% of what you have been doing. They don't know your secrets. But this one, you are fighting your worst enemy in your life, yourself.
Tai Zee, who goes by Apet China online, is known for his political commentary on social media and his writing as a columnist for various news outlets. Beyond his online presence, he has spent years as a lawyer, dealing with cases most people never expect to face in their life, from employment cases.
That company reduced her salary from 9,000 ringgit to 5,000, 3,000, then further reduced to 750 ringgit.
To divorce cases.
Male cheater and female cheater are almost equal. There's no, only male cheats and all these things.
And also family cases.
This family member who was accused of wanting to run away with her boyfriend actually sexually abused by her own family member.
In this episode, we look at how everyday situations turn into legal battles and how different the law looks when you're inside it.
People may ask, why are you defending that murderer? I say, who are you to tell that he's a murderer? CCTV is there everywhere and we have 100 pairs of eyes looking at how he stabbed another person in the broad daylight. I say, have those persons testify in the court subject to cross-examination? We are not supposed to be a judge because of what we see. We are supposed to put everything on examination.
Have you ever got emotionally affected by your case itself? Mr. Tai, when Malaysians get into trouble, most of them don't even know what kind of lawyers they should call. Do you mind shed some light on the different roles of different lawyers to us?
Okay, basically under Malaysian legal profession, the practice of Malaysian legal profession, there is no separation of lawyers or no separation of fields on principle. That means every lawyer are expected to know everything, but that is not the case. So usually you should engage a lawyer and ask that lawyer to recommend a lawyer that is relevant to what you are facing. It's just like we are going to a clinic and the doctor refer us to a specialist and whatnot because they know which specialist that we should go to, like ENT or what, we don't know. So just approach any lawyers and then we'll say, okay, this is criminal, I know this guy. Okay, that is civil litigation, I'll refer you to this and that. So just approach any lawyer.
So they would usually have their own network of, I know that guy that is specialized in media, this guy that specialized in crime and stuff.
Yes, if they don't, then just get another lawyer to get to intro to someone because among us, we do have some specializing field. Like for example, I myself, I do most of my cases are criminal defense, industrial relations, and family related like Juvenile, divorce and whatnot. So if you approach me for a general civil litigation like retrieving the money that your friend refused to pay back, I may not be the right person. I will say, look, I have this friend, my fellow learned friend who is specializing in this. Would you like me to call him or would you like me to refer? So that is how it works.
Yep. So is there a specific reason you choose that 3 particular branches you mentioned just now?
Well, just a reason personal to me because I like it.
I see.
Simply because I like it. I like to involve myself in criminal defense. I like to help employees to fight their employers. And I like to mediate between husband and wives for a better walk away terms rather than advocate against each other in the court. So these are things that I like. I'm quite capricious in that actually.
Well, I mean, speaking of what you like, I want to unpack that because obviously this is the main reason why we met you. I would really want to know more about, the branches that you mentioned just now.
Yeah, sure.
So, I mean, maybe just dive into more on the protecting the employees and the employers as well, right? Because I guess it goes both ways, right? When it comes to protecting them legally, right? So in the case of, let's say, the employment legal stuff, right? What are the most usual cases that you see?
Unfair termination. So there are cases where I handled a few times that is quite identical. It's where there is a new boss of a company and he doesn't like certain old staffs and he will find some reason to sack them. And that is the most common unfair termination that I have seen and have endured. But a lot of people thought that because of the contract, because of employment contract, you're not supposed to be late and whatnot, and you are sacked because of those reasons with warning letters and all these things, and thus the termination is lawful. That's not the case. So they did not know their inherent rights. Only those who feel unfairly treated will go to Malaysian Trade Union Congress or the Labour Office and they ask. Then only they realizes that they cannot be terminated so easily, so simply. Then that's where I step in, and then they have to have a reconciliation meeting with their bosses. There's a wide range of procedure that you have to follow, followed by bosses who does not know the right procedure to terminate their staff, even though their staff did something terribly wrong. They would just say, okay, tomorrow you don't have to come. Okay, according to the contract, I need to pay 2 months notice and that's it. No, there should be warning letter. There should be inquiry, though it's not mandatory, and that secures the boss rights more than doing things arbitrarily.
So do you have like a clear distinction of, let's say from the employer's point of view, right? What is the right or fair way to dismiss or terminate an employee in that sense?
First, you must not have personal grudge. I don't like him. I don't like to see her face, whatnot. It should be fair. Fairness should be the key things in your heart. Is it fair to terminate this employee because of this or that? That's the first mentality that all bosses should have in mind. Second, please consult an industrial relation lawyer or anyone or HR or whatnot. There are certain rules that employers need to abide when they terminate someone. For example, if that employee is not keeping up to the standard, you should put under PIP review. And when you want to terminate someone, look at your employment contract. What has that employee has breached? And that contractual term must not be against the law. There are a few laws that's governing in this employment relationship, which includes but not limited to Industrial Relation Act 1967, Employment Act 1955. You have Public Holiday Act. You have this and you have that. Even medical related things or even Companies Act may be relevant. So you must understand what are the rights of the employees guaranteed by this. For example, it is the employees' rights to have the salary that they're entitled. They may commit a mistake and you learn from some 小红书, don't know what, and say, oh, I will just withhold your salary for 50%. It's like a punishment. You are late, I will just deduct 100 ringgit from your total. You can't do that. Even though you stipulated clearly in your employment contract that if an employee is late, the employer is entitled for 100 ringgit deduction. That does not work.
Because it's not in line with the Act.
Yep, the Act says it very clearly in the Employment Act. There are only two ways to withhold the salary of an employee. Number one, if he voluntarily allowed it to be withheld, and even with that, 50% is at max. Like for example, he borrowed money from the company on loan. He took a loan from the company, and then you say, okay, I will deduct like 50% of your salary every month as a repayment. That is okay. Second, if he committed certain things so gravely that deduction of salary is imminent, you should write into the Employment Office, Jabatan Tenaga Kerja. And only when the Director General approves it, then you can withhold his salary. For example, due to his negligence, your employee's negligence, one of your wonderful, marvelous 20,000 worth equipment got destroyed because of a negligence that he should not, committed. That may be a reason for you to write into the Jabatan Tenaga Kerja for a salary deduction, and only after they approve. These are the things that the law guarantees the rights of the employees that often overlooked or even ignored, or even because of ignorance that was not being applied by the employer.
But you see, from an employee's point of view, right? When we talk about fair dismissal, right? It's a gray area. I mean, if you talk about fair dismissal from let's say employee, if the employer wants to terminate you, the performance improvement plan or PIP you mentioned just now will be set at such high bar where it's possibly hard for the struggling employee to even keep up to. So in that case, what can the employee do?
You can always file a case against your company under constructive dismissal. So there is another limb under Section 20 of Akta Perhubungan Perusahaan or Industrial Relations Act 1967. You don't have to remember the whole act. You only have to remember Section 20 because that's a very key word. So Section 20 also includes constructive dismissal. So what is constructive dismissal? Constructive dismissal, your boss did not sack you, but he committed a series of things or one-off thing or whatever things is as though that he is sacking you. So there is a precedent in this case. There is a manager. There was this manager from a cinema. I think it's the 80s or 70s. And his salary then was, if I'm not mistaken, 5,000-6,000 ringgit, but it was quite high pay. But he got demoted into a store manager with that pay for many years. So he filed a case against his company and said, yes, I was not sacked, but that such a disgraceful demotion is akin to the company is sacking me. So if you don't like the PIP because it's too stringent, or you don't like any things that the company is doing against your view or whatnot, like for example, suddenly they send you to some countries that they never told you beforehand, or cold storage or whatnot, you can always file a constructive dismissal claim.
So even a cold storage per se, right? I mean, for those that never heard before, cold storage, I've read people that, employers put employees into a room, not doing anything, just staff them out in terms of workload, right? And then they will just, after a few days, they will just give up, right? Those sounds legal, right?
No,
or are they illegal?
Illegal.
Illegal.
I need to, the word legal or illegal is in a gray area because illegal sounds like a criminal offense to me.
Yeah.
Okay, it's not about legal or not illegal. It's about that amounts to unfair. So what does it mean by constructive dismissal? So they did not dismiss you immediately, your employer. Instead, putting you on cold storage is a constructive act of dismissing you. That's where constructive dismissal or CD comes into
it's permissible.
Picture. It's permissible. You can file a case. Though, just now, under section, I mentioned about section 20. Either you are unlawfully terminated or you are constructively dismissed. If you are unlawfully terminated or unfairly terminated, it's the burden of proof that you have committed wrong lies on the company. You file a case against the company will need to explain to the industrial court or the labor court that you committed something wrong. And you have to defend to it. But if you want to file a constructive dismissal against the company, then you are the one that should provide and furnish all the evidences that the company is doing something badly akin or similar to the action of dismissing you.
So those
burden of proof.
Those of your clients that come to you as a lawyer, right, to defend them on this kind of case, right? I presume mostly are employees, right? Mostly, I would presume are more
Some
senior
employers
management or are juniors, right? Because
we have seniors and juniors.
Seniors and juniors. So there are juniors that actually know their rights and come to you for these kind of things.
Yep, there are juniors and there are seniors. I can give you an example. There's this one lady that we won the case, and what happened was that she worked for a series of company under the same parental company for the past 17 years. And that company, because of COVID, reduced her salary from 9,000 ringgit to 5,000, then further reduced to 3,000, then further reduced to impressively, pathetically, like 750 ringgit. That's below minimum wage, and that is really intolerable. She committed no wrong and all these things according to her explanation, and I advised her to file a constructive dismissal claim, and we did. So the claim includes from 9,000 ringgit drop to 750, the differences for these years, and also back wages, notices, and all these things totaling up to 6 figure.
Wow.
Okay. And the company's response was rather irritating. It annoyed me, and they say, okay, she always does not turn up to work and blah, 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 which is highly usual because as a responding party, I'm very sure that my learned friend will know to pick every little twinky problems about the employee just to fend off, just to defend the company. Anyhow, we won the case. That is because she was unfairly treated. You are not supposed to withhold her salary. How is she going to sustain her life and she committed no wrong. And the company even tried to say that, oh, he only works for this company for 1 year. So we only compensate as per the scale, 1 year equals to 1 month. So we only pay 1 month. I say, no, that is not tolerable. It's utter bullshit. And I managed to prove to the court that these are all the same company and she was internally transferred in a way. So there are many complications. You must endure a very tough mental suppression from the situation. You should already engage in your next job. You should know that this is about your rights and you have to sacrifice. There are certain risks that you may lose the case, but if you are not willing to endure the risk-taking factor, the life, the mental stress or whatnot, then give it up. The procedure itself is draining.
I see even in a recent case, right? Obviously, I can't name the company, but a senior management actually won a huge
Millions,
millions, right? Against a huge local alcohol company in this unfair dismissal. So I would say, that begs the next question, right? Is this just unique cases where 1 in 20 employee wins, or is it fair to say or presume that in a employment agreement, usually the dominance is on the hands of the employer? On average, right? Who do you think holds more power?
Okay, so this is my general opinion, which may not be the exact situation. The law is with the employee, but the practical force is with the employer because they have more resources to dispense, to use, and all these things. I give you an example. It's very hard to sack an employee because the law are always on the employee. And if you want to put it on a scale, I would say 7-3. The law takes sides with the employee by the scale of 7, and with the employer with the scale of 3. But when it comes to practical terms, the employer always find it at ease to hire a lawyer, always can find resources to counter-sue the employee for other things. Because some employee, they don't like the company, they got sacked, they will just post something on their social media, how bad, and all these things, and may result in a defamation suit from the company. So the company will say, if you drop your case in the labor court, then I will drop my defamation suit in the civil court. It happens all the time. But that being said, most of the cases, I believe that my learned friends out there will agree with me, settled amicably even before it reached the court. So there is an extra procedure in unfair dismissal that the law requires the employer and the employee to have a reconciliation meeting in the industrial relation department where it will be chaired by a fair third party who is a government servant from the Ministry of Human Resource. And that we don't talk about law. And Section 19 of the same Act precludes all advocate and solicitor to be present during that meeting. So no lawyers to play with legal jargon over there. And employee can be either represented by a union if your company has a union, or the Malaysian Trade Union Congress, MTUC. And a company can be represented by themselves or by the Malaysian Employer Federation, MEF.
So this is all before even the court?
Yep, before the court. But if there is a breakdown, no one agrees to anything, then they will refer the case. Before, a few years ago, when the minister approved, then only it goes to industrial court. So now the Director General can approve a case and refer the case to industrial court. Then only you engage a lawyer or industrial relation practitioner that you go for the legal procedure. But prior to that, I do not know the exact figure, but my feeling tells me that 80% of the case resolve in that reconciliation meeting amicably.
So I want to branch off and talk about more on another branch that you are also very heavily related and work in as well and experience as well, right? Marriage and divorce.
Oh, okay.
This one will get very spicy, right? Okay, maybe we start off right. Like, how common is divorce in Malaysia?
Well, according to the government figures, which I just read about, I think last year or this year, 80,000 pairs of divorce, which is 70 to 80% are Muslim, and the rest are civil cases, non-Muslim. About 20,000 of non-Muslim divorce in a year, and that's 40,000 of them.
But in terms of percentage of population, it's still very small.
Probably
very small.
But it's aggregated over the years, So 20 years a year, 20 years a year, 20 years a year. 5 years, you have 100,000 divorce already.
Wow, that's a lot.
Yeah.
And what are the common causes of divorce in Malaysia that you see yourself?
Well, what I see myself may not be, because different demographic will have different things. Number one is adultery.
Adultery?
Yeah.
Means cheating?
Cheating, yes. Number one that I know of. Then followed by...
that's what, 50%, 70%?
I would say 20 to 30%.
Oh, okay.
Okay. And cases that I handle, male cheater and female cheater are almost equal.
Wow.
There's no, only male cheats and all these things, just with these differences. Men, when it's just a general sharing that is unrelated to my profession. It's an observation that it's human nature that when men cheats and when it was exposed, men more tense nowadays compared to the olden days. You buy flowers, you try to reconcile with the wife, will kneel down or will do a video or whatnot just to reconcile with the wife, and the wife will get on or at her free hand to tell everyone, my husband cheated on me or whatnot. But when it happens on the other way around, men don't usually share out when they were being cheated because it's really shameful, embarrassed when you caught your wife cheating, and you just drain yourself. And that's why we always heard about male cheater but not female cheater, but for the lawyer who handled the case. So that is about 20 to 30%. Then it's followed by the case that I am handling. When you get married at a very young age, both of you are equally pure in your mind and have the same expectation and hope for the future. But 5 years, 10 years down the road, you have different priorities, different mindset, and you deviate too far from each other. And that's where you always have argument. You always think that the other person don't understand or comprehend you. You think that you are not being fairly treated by your spouse. And that is the second cause of divorce that I personally handle. Third one, I would say that it's not rare, but if you compile all the cases together, it fits in one category. Let's say the husband one of them suddenly involved in drugs, physical abuse, becoming lazy and refuse to work. And I would categorize this as a category itself. I do not know what's the term for this, because domestic abuse is a term, involving in illegal activities is a term, or
the mixture, basically.
It's a mixture.
But it's that one category.
Yeah, that one category.
That one side changed a lot.
Too much of changes. Until the society cannot take it anymore. And that will be the third most common thing that I handled before.
But usually, when they come to you for a divorce case, is it because of a dispute where one side doesn't want to divorce?
Well, there are two ways to do divorce. One you call the joint petition. One you call the single petition. The joint petition is where both sides came into terms.
Okay.
And lawyer will be like, okay, I can act for both of you. And let's discuss the term. And I should file in the court. You only have to appear for hearing in Kuala Lumpur, maybe 1.5 months to 2 months, we can settle the entire process. But when it comes to single petition, it's one and the other party refused to divorce or refused to acknowledge the terms of divorce. That's where you fight in a court. And that is worse in my situation, in my practice, it's worse than criminal defense. It's worse than death penalty cases. Because you have another person who knows everything about you, engaging a lawyer and expose everything under the sun in the court.
Wow.
Who knows you more than your spouse who you've been living for the past 10 years. They know you more than your parents. And they are going to expose every tiny little bit of you in the court. Doesn't that sound horrible? Yeah. Because the prosecutor, when they prosecute you for death penalty cases, they may not know 100% of what you have been doing.
Your secrets, yeah.
They don't know your secrets, but this one, you are fighting your worst enemy in your life, yourself.
And usually the ones that goes into this dispute and ask for a divorce is male or female or equal?
Both equal.
Equal.
We handle male and female. And usually, one refuse to divorce, you can always talk it through. You can always start by disassociating or a separation, apply for a separation order and all these things. Well, the problem with single petition divorce is that they cannot agree to terms when it comes to three main things: custody of the children, alimony, and assets. And that's where, if these three main issues got settled, we can always move on to a joint petition.
Kids and money, basically.
Kids and money. So we lawyers, I have a lot of learned friends. When I say learned friends, means how lawyers refer to each other professionally. They only do divorce cases. They don't do criminal like me. They don't do industrial relation. And according to what they told me, unempirical, but interestingly, 90% of their case, they withdraw and they achieve either a settlement, but in legal terms, either a consent judgment or refiling a joint petition. There are rarely a case like the 20,000 civil case that I mentioned, because Sharia have a different limb of law governing their marriages. Very rarely that you have a divorce case fight from the beginning to the end when the judge gave a judgment.
So have you personally yourself seen or heard of where one side just loses 95% of his fortune or her fortune because of this kind of divorce?
No. The court always assess fairness.
Okay.
Fairness means 50-50 and how far we deviate from 50-50. Less of punishment. Yes, there is element of punishment, but you won't lose 95% of your thing. Where the other party gets maximum of what the other party deserves, that's 50%. Because it's always 50-50 on matrimonial.
It's very fair one.
The court will assess from the fairness point of view.
Okay.
Yeah.
I mean, if it's a young adult without kids, then usually it's 50-50 . But what if with kids? Does it side to the mother?
This is what I read a lot of judgment, and even the judge reprimanded some lawyers on certain things. Reprimanded the husband and wife certain things. The welfare of the kids is the utmost priority of the court. So that comes first beyond anything. Any kids below the age of 18 is the number one consideration of the court. The welfare of the kids, what is the best arrangement for the kids, is what the court will assess and ascertain first before the fairness between husband and wife.
I see.
So welfare of the kids comes first. And if there's a single petition divorce, there is this thing that I attended bar counsel training and to understand certain things, but of no clear avails, is child alienation. So a lot of people ask, what if my ex-husband keep talking bad about me to my daughter when she was with him? There's no clear law that say you cannot do so, but there is consideration that the court will take. Like for example, I do acknowledge there are some judges who like to meet the poor kid individually without the supervision of the parents and the lawyers to understand the nature of the child alienation. So there are so many complications involved to ascertain what is fair. Whether the kids should be with the father or the mother, the timing, the assets, the alimony. It's hard to say here just over one interview.
It's a very common thing, especially in the Western country, to have a prenup, if not a post-nuptial agreement, right? Maybe you can explain a little bit more to me, right? Like how important is a prenup or post-nuptial agreement in Malaysia, and whether or not it is enforceable by law over here?
Well, in America, if I'm not mistaken, it's legally binding, but in Malaysia, it's not legally binding. It's not a document that you can tender to court and tell the judge and say, look, there is a prenuptial agreement, this house belongs to me, even after marriage, it's still mine. Well, it has some persuasive value over there because Section 56 of the Law Reform Marriage Act 1976 stated very clearly that the judge can always overrule anything based on fairness.
I see.
Yeah. So prenup, it may be persuasive if the judge cannot ascertain whether does this assets form part of the matrimonial asset, and that prenuptial, so-called prenuptial agreement may be relevant to persuade the court that it was intended not to be part of the marriage at the very beginning with this reason. Oh, I already pledged it to my brother. I'm quoting real life cases over here, you see. So there was this case, if I'm not mistaken, that there was this property that he is holding on trust of his brother. So he do have an agreement that acknowledge that this should not be part of the matrimonial assets. So during the divorce, when the wife wanted to claim that property, and then he bring up that prenuptial agreement, so-called prenuptial agreement, and he successfully proved to the court that does not intend to be part of the marriage matrimonial properties.
Oh, so it does work.
It does work, but it's on persuasive value. That means the judge, okay, there is this word called legally binding and persuasive. Legally binding means in America, you have a prenuptial agreement. If I'm not mistaken, and the judge says, okay, that is how it should be. But in Malaysia, the judge can overrule.
I see.
If it's deemed as unfair.
Okay, let's change and switch up a gear a little bit towards a bit more sensitive topic, criminal, right? Something up your valley.
Yes.
All right. Okay, so I mean, recently there have been cases, especially in the juvenile scenes, right? Where you have stabbing cases in SMK Bandar Utama Damansara 4, where, you know, a poor girl, 16 years old, got stabbed more than 200 times to death, right? Obviously, the guy, you know, the perpetrated guy, right? Wow, legal terms, right? Got charged for murder. But then again, for most of us, average Joe watching this, the non-legal person, right? Is that a sufficient charge that he should be facing, right? Because there's no death penalty for a juvenile and things like that. What do you have? Do you have any view on this?
I put it this way: when talking about juvenile cases, which I handled a few, there is this term called dolly in car parks. Dolly in car parks is a Latin term that deems those who are age 9 and below in Malaysian terms does not have the capability to commit crimes. So you cannot charge an 8-year-old kid unless you can prove that his mentality is beyond 8 years old. His mindset is beyond 8, which is highly doubtful. And there are laws, the Akta Kanak-Kanak Child's Act 2001, that states that those who are below the age of 17, I think 18, are children. They are incapable of carrying the mental capacity as an adult, and thus they cannot be charged like an adult unless proven the other way around. So now, if you read the news, I think when this video is out, that should be out too. They keep waiting for the assessment, the assessment on the child's mentality by the Jabatan Kebajikan. So they always have this as to assess the child's situation and whatnot. So as a child, you are not supposed to be tried like an adult, regardless of the consequence. So that's the difference between general public and legally trained person. When we look at procedural fairness, we disregard the outcome first, one step at a time. So people may throw a tomato towards my face and say, do you know that there's a person who died, a poor, innocent 16 years old girl who has a bright future? I say, yes, I acknowledge that. But let's look at procedural fairness first. If kids are to be tried like an adult, isn't it an unfairness itself because he does not know the consequence of whatnot? Maybe this boy does, but majority of them does not. And probably there should be some exception to this. But that being said, detained under the king's pleasure, it can be a lot of years. It can be panjang hayat. It can be until you die naturally in the things. And I thought that murder is a crime that you cannot forgive and people should be hanged and whatnot. These are things that separate the professional legal personnel from the publics. Then we will, in a general way, disagree to each other when we talk about procedural fairness.
Okay, let's talk a bit more about the criminal cases you have handled before, right? Like, can you recall like one most bizarre, cases that you handled before that you can share with us?
Yes, of course. And because I'm not going to expose the names or whatnot, and no one will find out. And I'm going to make a little bit of cover up over here so that it does not compromise my professional etiquette. I can only share with things that are reported. Okay? So there was this case where a family member approached me and claims that another family member is going to be kidnapped by someone. Okay? So I escorted this family member to make a police report, and the police does came and investigated the case. But what the police found out was quite astonishing, quite shocking. This family member, who was accused by another family member of wanting to run away with her boyfriend, okay, who is a minor, actually sexually abused by her own family member. And the police investigating officer actually did not tell me anything, but to advise me not to represent anyone anymore if allowing them to do the proper investigation. And it stops there. And eventually I was told that the main perpetrator who sexually abused this family member was prosecuted. So I was in an awe situation. Why am I talking to this guy? And then the so-called kidnapper, actually the boyfriend, wanted to protect this family member. And then when they were prosecuted, of course they called me, but due to certain reasons, I did not take up the case. That's one of the most shocking case that
have you like also witnessed yourself like where cases have very unfair outcome yourself?
Rarely
lah.
Okay, put it this way. Fairness in our eyes and fairness in the eyes of the public are different. So if you're on a civil case, you always think that you are on the upper end.
Yeah.
Your opponent always think that they are in the upper end. Whoever loses a case will think that it's unfair. And this is how the procedure works. When you file an appeal against a judgment, you start by saying, the learned judge erred in this. Mahkamah tinggi telah terkilaf dalam ini. Terkilaf means you did something wrong.
Yep.
So you are trying to tell the appeal court that the judge was wrong. That's how you start your statement, your notice of appeal, your record of appeal, by telling the higher court that the lower court is doing the wrong thing. Does that amounts to unfair? Because that's always how you start. And if you win in the court of appeal, that means what the high court judges, the judgment was wrong. And it's tend to be corrected by a higher court. And when you win the case in the federal court, that means the judgment by the court of appeal is wrong. And it's overturned. So anything that got overturned, there is a little bit of unfairness over there, isn't it? Because without your appeal, that could have been the precedence. That could have been the case. So the nature of our judiciary system, in my personal opinion, is to achieve fairness on one condition. That's to maintain order. Okay, I did not say that fairness is not important, but fairness is not to be defended 101% against order. So I'll give you another example. How does order prevails always fairness? Even in the UK, or in Malaysia. In the UK, I'll start with UK first because that's where our law was derived from. Before 2005, there was this law called the Adverse Possession Law, based on RRA 1925. Adverse possession being, before 2005, they changed the law already. If you occupy a land that does not belong to you for more than 10 years, that land belongs to you.
Okay.
Is it fair?
Hell no.
Hell no, right?
Yeah.
But what's the reason? Because of public order and economic growth. If you do not use the land and someone else use it and develop it, it does not stop the country from growing. If I protected your ownership over that land, means I'm telling the world that I'm okay if someone owns a piece of land, make it empty and vacant over there for 30 years so that it can sell it at fetch a higher price in the future. So economy will get stagnant because everyone will buy land and wait to be grow. So order came first or fairness came first?
Order came first.
Now comes to criminal defense in Malaysia. There's this thing called beyond reasonable doubt. You know what does it mean? If you watch a movie, the prosecution have to prove beyond reasonable doubt. So if the prosecutor have to prove beyond reasonable doubt that Zid have killed Tai Zee with this knife, what will your defense lawyer be doing in the court? Prove your innocence? No. His job is to cast reasonable doubt. There is a doubt that this knife may be used by another person. I don't need to prove your innocence. I only cast doubt.
Mm.
Fair? Is it fair for the victim?
Not fair.
But if I don't do that, then a lot of innocent people, based on lesser magnitude of evidences, get sent to jail. So in the criminal judiciary, in the criminal justice, defense counsel do not strive to prove a person's innocence. His job is to assist the court to ascertain whether the prosecutor have acted beyond reasonable doubt. That's all.
Have you ever been in the shoe of that defense lawyer where you have to defend a alleged criminal that is sort of, right, quite clearly already guilty already?
Well, that comes into a question that I've been answering for the past 10 years, and I would love to answer it now in my way. First, my first duty owes to the court, not to my client. Second duty to the client. Number two, my job is to assist the court to come up with a judgment whether to convict that accused or not. So that's my job. It is not my job nor my capability to have a preconceived judgment whether my client is a criminal or not. Because at the end of the day, only God knows. Only the universe knows whether he committed the crime or not. He himself may not know. For example, Zee, you come to me and say, Zee, I was charged for murder. Can you defend me? My next question is, why should I believe you? Because you told me you charged. Oh, there's CCTV anywhere. Let's look at it. Then people may ask, Zee, why are you defending that murderer? I say, who are you to tell that he's a murderer? Yeah, CCTV is there everywhere. We have 100 pairs of eyes looking at how he stabbed another person in the broad daylight. I say, yes. Have those persons testify in a court subject to cross-examination? Yeah, everyone under the sun will know. Every reasonable man will know. How do you tell? Have you put a psychiatric assessment on all of them before you make such a thing? Have you seen these old people? You have to put on the glasses. Have they seen the right person? Probably he has a twin or whatnot. It could be anything. Let's put it on a trial. And according to the principle of law, everyone is innocent until proven guilty. We are not supposed to be a judge because of what we see. We are supposed to put everything on examination. And that's why we call it examination in chief. If I summon the witness, or cross-examination if I am asking the question from the prosecutor. So with that in mind, in my mind, there is no criminal until the court has examined every pieces of evidence relevant and the court have come up with deliver a judgment that he's a criminal. But when he is a criminal, I have no job already.
Yeah. But
so I never defended a criminal.
That's from a professional lawyer perspective. But how about the human side of you? Have you ever got emotionally affected by your case itself? Like in this sense of you have to defend someone so hard that is in your mind, in your hunch, you already roughly know it's not just alleged, it's already more or less just waiting for the time to be convicted. Okay. Has it affected you emotionally?
I will be lying if I say no. At the very beginning of my practices, yes, it affects me. But that is because I have preconceived judgment that my client did something wrong. That is a personal thing. Okay? So it works the same when the doctor is operating the one who killed his father. It's the same dilemma that we are facing over there. But as a doctor who have taken Hippocratic oath, regardless, you are when you are with your white robe as a doctor or your black robe as a lawyer, you are not yourself. And that's what we meant being professional. You are no longer yourself. You are just a flesh carrying out the duties imposed by that robe, by that professional office. And you're not supposed to have your personal feeling into it. And when I speak to my client, I don't speak as a friend. And if I want to speak as a friend, I will leave it to later and say, okay, take out that professional mindset. I'm going to talk to you as a friend, because they find me very intimidating when I speak as a lawyer. I just want to get things clear. I say, I don't want to know this information, skip and all these things. So with that in mind, now, after many years in practice, for me, it's like, my job is to assist the court to ascertain whether is there a beyond reasonable doubt advocacy from the prosecution to convict this person. And pretty much that is all. And you pay me to assist the court in as coming out with a conclusion and coming out with a decision. And that is all.
But it took you many years. Like, was it
Mhm.
hard in the early stages for yourself?
Yes, it does.
It's pretty normal, right?
You see, developing a professional mindset is harder than acquiring the professional qualification itself.
Wow.
The mindset you need to groom. It won't just happen overnight after you acquire that qualification, regardless of which profession. And that, I have a generic answer for on behalf of all the professional out there. When you need a license to practice certain field, doctor, engineer, lawyer, whatnot, there are reliance on laymen on your skills. There are etiquette and duties that you must obey, abide. And when that comes in place, because certain people claim themselves as professional, but that is not really a profession. Like, for example, you do not need a license. There's no reliance on all these things. These are not profession. No, in terms of verbs, it's professional in terms of description or noun or whatnot. So when you develop a professional mindset, the first thing that you will do is a switch of personality. You're a professional counselor. You don't invest your passion, your sympathy. It destroys your profession. If we do have personal passion and all these things, you may want to be a constitutional lawyer to fight for rights and a general thing, but not on a procedural fairness cases that you need to advocate on certain things.
So do you think that over the years have changed you as a person? That the professionalism changed you as a person, your character in real life?
Yes, it does. I give you an example. This very simple notion of innocent until proven guilty. Can you absorb that? For the 14-year-old boy, innocent until proven guilty? Well, I believe that most of our audience, 99.9%, maybe that 0.1% of fellow practitioner like me, will think that he is guilty as charged. No doubt. But my professional mindset tells me everyone, that boy included, is innocent until proven guilty. And I will be accused of being cold-blooded, disregarding the facts. And it's just common sense. You lose out your common sense mind. Because we are professionals, we have to set aside common sense. And after we discharge our professional duties, then we will come back to common sense. That is required of us.
That's fair. That's very fair. Someone still has to play that zero emotion role to make sure that order is kept in place.
That's correct.
Okay. So let's move on towards something. Do you cover will?
Yes, I do.
Okay. So let's move on towards a subject that may be out of touch for most people, right? Until it's necessary. Let's talk about will.
Yep.
Right?
Yep.
So
Love
have
this
you
topic.
personally witnessed like any family disputes or over will or no will?
All the time.
All the time.
All the time. All the time.
Tell me more about it.
Okay. Actually, it's happening now.
Wow.
Okay. So, I do have clients whom I should not tell because will is not like an open case and whatnot, but I can share with you how does it works, which is unfair. And that triggers certain things. And I can give you an example arising. It's not a particular case, but a few cases combined. A father who will property A to the first child, property B to the second child, and property C to the third child. It's a hypothetical situation, but it applies. But before he passed away, property B was sold.
Okay.
So when he died, property A goes to the first child, property C goes to the third child, and second child gets nothing, though it was mentioned in the will. And the second child will say, it's fair and square. Probably the father just forgotten about things. So the second child was like, hey, brother, to be fair with me, why don't these two property combine and we all get the 1/3 of the share?
Yeah.
So the third son and the first son will say, no, that's what our dad gave me. It's my rights. And that, you have the drama. The second child will file a caveat and then want to challenge the rights and all these things. And they say, the spirit of the will is as such, but he has sold the thing, blah, 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 blah. Or we have a veto
Mm.
challenging the will because the husband, before pass away, have committed adultery. So when
you
he
can do
committed
that.
adultery, you can't just will anything at whim, because under the Law of Reform and Marriage Act, your wife, your spouse are entitled to certain things out of their marriage. You no longer become the sole owner of a matrimonial properties. So
Even
you
if
can't
there's
will.
a will in place already.
Yeah, you can't will something that does not belong to you by
Okay.
law. So first wife, second wife, family fight law.
Wow.
Okay, a lot of stories.
Okay.
A lot of stories.
What was the most dramatic one? That one.
Actually, almost all are dramatic. Almost okay. There was this one case. So the father will everything to the son, and the daughter was the one that take care of the father. Before the father could pass away, he wanted to change the will, but before he changed the will, he passed away. And that will is supposed to have everything to the daughter. There was a draft. Yeah.
Unsigned yet.
Yes, unsigned.
Okay.
So the daughter is trying to claim certain things. There's also another case where, okay, the other case I should not share here because it was quite specific and it would have known by other people.
No, it's okay.
But it all started when children or beneficiaries have established reliance on the inheritance. So if there's no, I have seen a lot of peaceful things. There was this one case that he willed everything to the son and willed absolutely nothing for all the daughters.
Wow.
And guess what the son did? So 2 brothers and 5 sisters.
Yeah.
So the 2 brothers actually say, look, Dad wants us to take care of you. So let's split it. Everyone is happy. So the 2 sons combine everything and split among all the sisters and they got equal amount. So I have a lot of peaceful stories as well, but peaceful stories are boring, but it's beautiful. I do have one case, I posted about this with the consent of my client, that the mother knows that one of the child, okay, the elder sibling is A, younger sibling is B. So he knows that B eyeing on a lot of things, but A was the one that take care of her. So she make A the executor and will the house and most of the money to B. And then when A sat down and said, I took care of my mother, and then when she passed, she gave everything to B.
Yeah.
And I say, wait. There's a letter. So the letter says that the mother knows that B will ask for everything from A and she doesn't want that to be in that way. So that will that I read out, apparently it was drafted by a very senior lawyer and I thought that he was the smartest lawyer in town. It's going to be superseded by another will immediately.
Oh.
Yeah. So the one that I read out superseded by another will on instructions with video records and whatnot. The house still give to B. The money still give to B. But A being the executor, B has no business over the transaction. But there was another thing, the life insurance, which is more than what B is receiving, all goes to A.
Oh.
So B does not know that A actually inherited a larger amount, life insurance.
Or he or she doesn't know.
She doesn't know. They doesn't know.
But what if they don't? Will that add a complication to that?
No, because it was clear on the second will. So B will still get the house and certain sum, but A will get the money. So that layer of protection, because the mother knows that B will definitely ask for something, challenge for something if you know the amount. And then, of course, we have many stories about this.
But just now you said that most of the dispute comes from situation where the heir already established, where there's a certain reliance on already gonna pass away, we are gonna share like that based on the will. But have you seen where there is a perfect situation where there is a proper signed will, then the parent pass away, etc., and then dispute comes in afterwards and destroy a totally peaceful family?
So far, I have not endured this kind of extreme situation. But I do have this case where where the offspring, the heir, inherited things improper. So there are properties, there are cash, there are company shares and all these things. Then suddenly a debtor came. So when the debtor came, the eldest kid actually paid off the debtor using the money that he inherited. And when he asked other things from his siblings, that portion, a portion to the debt, they refused. So they fight each other.
I see.
Yeah.
So in that case, they come to you for this kind of dispute.
Just consultation.
Just consultation. But ultimately, it got resolved peacefully.
Yep, resolved peacefully, because sometimes lawyer we would try to advise client, if gain sufficient trust, not to go to the court, because you are only feeding the lawyers. If you can resolve amicably, I will tell you the law, I will tell you the precedents, I will tell you most likely if we presented all these things to the court, what will the court ascertain? And why don't you just do it now? No point fighting. You are feeding the lawyers, 3 of you, 4 of you, 5 of you. If 5 of you hire 5 lawyers, then we are making tons and tons of money.
That's true.
And you will still get the same outcome.
So for the average viewer watching this video, right? Do you advise strongly to get your will written?
Now, immediately.
Immediately
accept. Okay. First, I remember having to make one caveat and one suggestion. Will writing only, the Distribution Act, the Distribution Act only applies to non-Muslim. For Muslim viewers, there is Hukum Faraid, which subject to the Sharia court's rule on how you should apportion your inheritance. It's totally different from non-Muslims in Malaysia. But why do I ask you to write a will? If you do not write a will, then it will be subject to letter of administration under the Distribution Act. Okay, then the law presides. Your kids will get 1/4, your wife your kids will get half, your wife 1/4, or your husband 1/4, your family member, blah, 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 blah. So what happened is that I do have this case where a father passed away, the wife gets 1/3. The wife gets 1/4, the mother gets 1/4, the kids get halves. But in few months after the father passed away, the grandma passed away. Okay. That 1/4 of grandma's portion now, all the father sibling suddenly has a right to claim. And the whole thing is just a company. So the shares in the company. The father only left the shares in the company. So now all the uncles suddenly wanted the shares of the company which they inherited from their mother, which is the grandmother. And they may have some complication in that. So the most common template will that I have is when a husband dies, everything goes to the wife. When the wife dies, everything goes to the husband. If they die together, then everything shared equally among the children. So this is the most common template that I have. Why? You must sign concurrently. So there are cases where the husband signed as such, but the wife does not have a will. So after the husband died, things goes to the wife. But the wife died, then the wife's parents get entitlement.
Based on the law.
Yeah, based on the law. And the wife's parents pass away, then the siblings then they fight over a house, a windfall, and all these things. Don't take things so lightly. Why? Because you won't know whether your relative suddenly is in dire need of certain money to save themselves. They may be owing money to banks and almost declare bankrupt, and suddenly there's a windfall, and they will think that it's their inherent rights, where under the eyes of law, it is their inherent rights. I've seen cases. So just get it can be as cheap as 500 ringgit with a template. Don't come to me, because I'm not supposed to promote all these things. Or find a local lawyer and say, I want to draft my will. As simple as, if I die, everything goes to my wife. If my wife die, everything goes to me. If both of us die together, everything goes to the kids.
So it's a very fast and simple process that people just don't
You don't even have to reveal your assets.
Oh.
It's everything, isn't it? Share equally among my kids. You don't even have to reveal. You can always have a list of assets attached to the will for your own reading. Because according to the will, everything goes to your wife. Everything goes to your husband. Everything split among your kids. So you don't even have to write out the list of assets for the lawyer to type it out.
Oh, you don't even need to tell the lawyer.
You don't need to tell the lawyer. as so long as you have percentage
But
and
how
whatnot.
would the lawyer be able to know everything that you got
We don't
savings
know.
account?
We
You don't.
always file for amendment in the court, the scenario asset or the list of assets. Suddenly, the beneficiary will come to me and say, "Oh, Mr. Tai, actually we found our father owned this share in their company. Okay, I file amend. Oh, our father owned another house somewhere. Okay, we file and put it in. We don't know. So I will advise my client who wants to draft a will, if you don't show me what you have, probably you don't trust me. As a person, I don't need your trust anyhow. I just need to draft a will for you. But always, before you pass the will, I always do 4 sets. One keep by the lawyer, one keep by the executor, and one your own safekeeping, and another copy for anyone that you can trust, a brother or whatnot. So when you have this will, just put a list of assets that you have with that will, seal it, and keep it.
Even if the asset list is not complete.
Just write whatever you have, whatever you own, your cars, your shares, your assets, your company and whatnot. Just keep it. So if anything changes, just take out, put it and put it back. So it is not part of the will, but it comes along with the will.
How does the lawyer know that asset list exists if you don't give the lawyer?
I don't need
You
the
don't
list of assets. I only need to know that everything goes to your wife, unless you have special arrangement. Oh, this house goes to this, that house goes to then you have to list out one by one.
I see.
Yeah. One tip for everyone about will. You married, you write a will, you divorce, the will stands. But if you remarry again, the old will invalidates. A remarriage or a marriage invalidates previous will. So your will is dated on the 26th of December 2025 and you got married on the 1st of January. So that will no longer valid. So a marriage will invalidate a will, but a divorce won't.
I see. So it's like, in employment terms or commercial terms, it's like survive post-termination.
Yeah.
But why would you recommend that?
Because a lot of people remarried, but they did not know that the old will was superseded by a new marriage.
So it was intended for the previous wife, something like that.
Or some people who never get married, already have a will at 55 years old, and then suddenly 60 years old, found someone he loves, and thought that the will still stands, and then say, okay, let's be a companion. My thing is still my thing, your thing is still your thing. Let's get married. And in his mind, it's like, I already have a will in place. Everything goes to my my charity, let's say. Then suddenly he died. Then the wife wants to claim everything, and they say, oh, there's a will, everything goes charity. Oh, that will was dated before our marriage.
Okay, that makes sense. But for the average people watching this, right, if they say, I also don't have much money, 100k, 200k asset only, need to do will meh?
Just do it lah. Everything will to what? That's all.
So there's no like, maybe this amount you recommend or what?
Okay, this is what I will advise people to do. So the simplest form of a will, name, IC, address or passport number, address, name an executor, the one that will execute. It can be same as your beneficiary and 2 witnesses who are not your beneficiary. You can write it on your own until you think that you are wealthy enough to get a lawyer to draft it properly. Just have that in mind first.
So that will is active as long as you're alive?
Yep.
Active until cancelled.
That's correct.
So what if the particular lawyer stop practicing?
We have to pass to another lawyer. You see, we can't just stop our case over there. Before you close down your firm or stop practicing, then the bar council will ask, so who is taking over? So I do take over some wills from other lawyers as well.
Okay, Mr. Tai, we have covered quite comprehensively. Actually, I think I just scratched the surface based on your experience, right?
I hope that I didn't bore your audience.
There's so much more that I can ask, but in the spirit of time, right? Obviously, there's still many branches that we didn't touch, right? In terms of as a lawyer, right? So for an aspiring lawyer or someone that are just, curious about this particular field, right? What would you say to them? Would you recommend them to pursue law or not?
Okay. For those who aspire to be a lawyer, you must understand one thing. Becoming a lawyer and wanting to be a lawyer is 2 different things. It's just like a Lego. You see a very beautiful castle built by Lego. That is lawyer. And then when you study law, it's like how to make this brick and all these things. But becoming a lawyer is actually making that castle by a Lego yourself. Is a totally different things. And often I found a lot of my classmates drop halfway. So you must understand that why you want to become a lawyer at the first place. Of course, we do have the generic answer of what fight for justice, passion, all these things. Yes, it does. It does plays a role even until today.
Yeah.
However, being said, you must understand that it's a profession. Profession means you have to tweak your mind, like to understand what is innocent until proven guilty. Can you do that? That's number one. Number two, you must understand that you must have passion in delivering discharging responsibility. It's not just I want to make money. There are many other ways to make money. If you don't have passion in drafting documents, you don't have passion in arguing in court, you don't have passion in soliciting on a deal or conveyancing and all these things, then you will find your day-to-day life is unbearable, because as a chambering student until a legal associate, a junior lawyer, you are required to, if you aspire to be a well-paid lawyer in a big firm, sometimes you don't have a weekends and you have to work until late night.
Are there really like easier or harder specialization within?
Yes, of course.
Which one is easier per se and harder per se?
Probate, will.
Probate, will, and
joint petition.
Joint petition.
This is easy.
That's the easiest one. It's just process.
It's just process. It's just struck terms and all these things and blah blah blah. And conveyancing is slightly harder because you have a lot of procedural matters, your borang this and kanun tata cara, your kanun, your national land code requirements and what these things.
But conveyancing is like contract drafting.
Yeah, that's correct. Conveyancing is like SPA and whatnot. And then criminal defense is middle, because
so those are on the easier end.
Yep, easier
so
end.
The middle is
criminal defense, because my job is to cast doubt. Okay, it's not that easy per se. It's not really easy, but it's on the easier spectrum on difficulties. But
you have to be quite creative when all the,
that's correct.
Right?
You have to be sharp and correct, and sharp and creative. Then civil litigation, on industrial relation, on single-petition, on debt recovery, all these things is harder, because you must understand that you are fighting a fellow lawyer like you on a balance of probability. That means each of you are 50-50. Whoever gets 51% wins the case. But for criminal defense, prosecution has to prove 90% beyond reasonable doubt. I only have to cast reasonable doubt, not any doubt, but reasonable doubt. So it's like 8-2. Onus on prosecution 80%, with the exception of drug case, because reversal burden of proof. I have to prove that my client does not traffic the drugs, instead of the prosecutor have to prove that my client trafficked the drugs if they found in possession. So it's a very complicated thing, but that is just an exception. Corporate is hard. Corporate is hard because you are trying to make money and you're trying to foresee a lot of future trouble beyond the eyes, beyond the scope of an ordinary person.
When you say corporate, do you mean like conveyancing corporate?
No, conveyancing. I'm talking about
M&A?
M&A, due diligence, drafting a corporate agreement and all these things. It's not just ordinary conveyancing anymore. It's a very specific area of practice, corporate. And you must know directors' duties, the newly implemented Section 17A, where director can be prosecuted for corporate corruptions and all these things. And further than that,
but usually corporate is done in like a huge team, right?
Yeah.
It's not like one person solo a big project.
That's correct. Usually it's
then you
team.
got legal advisor and things like that. So wouldn't that make it easier per se?
If you have specification of things that you have to do, like you may achieve an economy of scale kind of easier, but it's not easy. You need to have a lot of skills, knowledge, experience to be a good corporate lawyer. You need to give the right advice. So you may start as the drafter, you may start as the reviewer, but at the end of the day, you have to pick up everyone's else skills to be a good corporate lawyer.
Understand.
Then above that, in my personal opinion, appeal lawyers. Those who only do point of law appeal. So
climbing the hill.
It's not about climbing the hills. Okay, there's a general misconception on layman's on how appeal works. You do not have witness called in court of appeal or federal court.
What
you
do
don't
you
call
mean by witness call?
You don't call witness, you don't testify like usual. That is what we call a trial court. Mahkamah bicara. And that ends in high court. When you appeal, you only appeal on point of law. So what is against point of law? Point of law? Point of fact. Did you commit that crime? Was that action legal or illegal? Did you kill him? Yes, but I'm killing on self-defense. So this is point of fact. You have to prove that you committed a thing, and this is point of law. It is legal or illegal to do so. A soldier who take a gun and shoot at the enemy is perfectly legal to kill, though it qualifies under Section 302, intention to kill and shot. But he's a soldier, police. So you only appeal in point of law. There's no more witness called. There's no more cross-examination and whatnot with jury. Malaysian don't have jury, but if you know that all this thing, they're fighting and all this thing, you only appeal on point of law. The judge is wrong in making this decision because point A, point B, point C, and then submit your case. And the other side did the same, and then appeal. So appeal hearing usually 1 or 2 days. But for trial, maybe 1 year, 2 years. So appeal lawyers for me is a very niche litigators. Some lawyers, they do trial all the way to appeal, but some they only do appeal cases.
So is it correct to assume that the harder is the niche, the more money there is?
Yes. So there are some cases, very specific cases like IP, like certain criminal offenses like corruption, all these things. I do heard that some very renowned lawyers charge 500,000 for appearance.
Wow.
Yeah.
But it's very mentally taxing.
Yep, that's right. Or $1 million sometimes.
One got to also balance that whether they are really capable or want to, passionate enough to do this kind of thing.
That's correct. It's just like doctors. I always like to make a comparison with doctors just for the matter of perspective. And like you're going to perform a very, very specific neurosurgery, and only 2 in Malaysia who can perform that. How much will you charge for that surgery? That you have to stand for 32 hours. That it's require a very specific skills. Maybe $1 million or 2. Same goes to a specific limbs of law that the best in town, the best lawyer in town. He may charge 500,000. People like me may just charge 10,000. It's just like, so people goes back to your very first question that links to this. How to get the right lawyers, right? It's like, what's the best watch?
There's no right answer.
There's no right answer. 90 ringgit Casio may be the best watch. Or the 100,000 Daytona may be the best watch for certain people. So, no one is good, no one is bad. Everything comes with a price. And if you want to be the best lawyer in town, for me, my advice to you is judge the passion you have in the heart. Is it for money, prestige, or that particular thing that you want to achieve?
For most Asian households will be more on the prestige and money, right?
If you are willing to sacrifice your daily lives, you are willing to do things that you don't like to do for money, a lawyer probably is one of the best choice. Doctors also, engineer also, YouTuber also.
So, okay, let's move on towards something more lighthearted, right? I just want to understand, because this is like a flagship of the show. We always ask our guests, right? Because they are experts in different niches. We want to know how they manage their money, right? You can be general, you can be specific, up to you, right? I want to know, like, as a seasoned, experienced lawyer yourself, where and how do you save your money?
I'm not seasoned and experienced. Okay, I deny that first. Okay, I do have chunk of my money saved as a fixed deposit, and that is for that's for emergency contingencies. I won't touch the money over there.
Okay.
Then another chunk I invest in the share market.
Local or foreign? Local.
I'm not too like to do foreign investment just yet. And a small chunk I keep in mutual funds.
Okay.
And I still contribute to the mutual fund on a monthly basis. And I contribute monthly to buy gold, paper gold. Regardless of the price. So for my shares, I divide into 2 portions. One portion is blue chip stocks.
Okay.
So blue chip stocks, I would just pump in money that 20% of my post-tax income, I will just pump into the CDS account, and I'll just pump into 7 blue chip stock. Whichever is best price, I'll just buy. I'll just buy, just leave it there, go ups and down. And another portion, I would love to try something called scalping.
More active trading.
So there's another portion I will do active trading whenever I'm free. So once I've done a deal, I'll just sell off, and then put it in my CDS account, wait for the next one when I'm free, and then do it on scalping. And usually by 1 to 2%.
You mean like gains 1 to 2%?
Yep, then I will sell. I won't,
But in terms of portfolio weightage, is it like 50% blue chip, 50% scalping, or?
yeah, 50-50.
Oh wow,
It's
that's
a 50-50.
pretty huge.
Yeah, and now I'm facing some, given the current situation in the share market, the scalping part of I got stuck.
Okay.
But the blue chip part still carry on as usual. And I also spend a lot on insurance. I am a person who is afraid of uncertainty, and especially comes to health.
Yeah.
So I buy many different medical insurance.
Oh.
And I don't buy life insurance because after I do my calculation and compounding interest and whatnot, I thought it's not worth it, so I don't do life anymore. So I do a lot of medical related 10 illness, 100 illness and all these things.
I see.
And because if I'm not mistaken, I need to review this, so don't take it 100% from me. It's just sharing what I'm doing. That let's say I got certain illness, if I already claim from one medical insurance, no other insurance will insure me for that particular illness anymore for the rest of my life. I only have one chance. But if I already insured for 4, yes, I claim 1, but the other 3, they may increase my premium, but they still have to cover that illness because I never claimed from them. I never wanted to buy get a loan and buy a car. I always do cash on second-hand car. I never wanted first-hand car. First-hand car is the shittiest idea for me.
For depreciation purpose.
For depreciation. So my first car, with the aid of my father, a loving father, I have to confess, I have a loving father. It was a first-hand car, and the only first-hand car. Then my second, my third, second-hand cash. Because the car loan, is not like your house loan where you can pay interest upfront on all this thing. Not worth it. So if you cannot afford a cash second-hand car, then I would just go with whatever I have. I co-own a house with my brother. I'm looking for another house now. And that is how I spread my income.
So property is not your main thing as well?
No.
So from what I hear, you don't do money market fund, you don't do crypto, you don't do bonds as well?
I am looking at crypto.
Okay. Just a tiny bit.
No, I have not started.
Okay.
So most probably I will start with Bitcoin, but I'm trying to understand the fall of Luna and do some research on it and see whether Bitcoin can convince me to do it as a long-term investment or not. And after Bitcoin, probably I will look at other like Ethereum and all these things. Yes, I do have interest in cryptocurrencies, but I need to understand how it works first before I go in.
So you will look into crypto before US stock market?
That's correct.
Interesting.
Yeah.
Why
Where
not?
stock market sounds, because I could not possibly understand the nature of how US corporation works unless you are talking about the S&P 500 general stocks. Or probably just buy Class A stock of Berkshire Hathaway. I would not know. The fluctuation looks like a gambling machine to me. The fluctuation.
The volatility is too
the
high.
volatility of Nvidia, of all these things that everyone is looking at. So if there is US stock that I want to pump in, it's either Berkshire Hathaway or S&P 500
Index.
The index fund. Yeah.
Fair enough. Fair enough. Okay. So, Mr. Tai.
Yep.
One last question. If you could change one thing in the past, what would that be?
I would have listened to my mother when she said, "Don't eat too salty. It will cause you to lose your hair." Please listen to your mother. If your mother say, "Don't eat salty, it may cause your hair," listen to her.
Salty, not like sugar.
Yes,
it's worse.
Because I have a very heavy tongue. I like to eat things with flavorful things, and my mom keeps saying, probably that's the reason I have hair loss problem. Probably, but I have a twin brother. He doesn't. He has beautiful hairs like yours. So the main difference between me and him is I eat a lot of salty thing, and my mom will say, 不要吃这样咸啊，吃了咸掉头发。I said, what is the 掉头发 thing have to do with me? 没有头发，没有头发啦。Then now I'm facing the problem. If there's one thing I want to change in the past, on a lighter mood, this is what I want to change. Eat healthier. But on a serious note, if there's one thing I want to change in the past, I would like to start my exercise routine way earlier than now. Whenever I get to tell my younger self, I only started my exercise routine of running, of gym, and brisk walk last year. And it changed my life in total. If there's one thing to change, that's the thing I want to change. I would have started at 15 years old, 14 years old.
What were the changes that you noticed in 1 year time?
Okay, I used to get tired very easily in the past. And I used to get unexplainable fatigue and pain here and there because I'm a lazy person. I sit down most of the time. I like to eat. I eat unhealthily and all these things. I was fatter than now. So compared to June last year, I'm 16 kg lesser.
Wow,
Yes.
that's a lot.
Yeah. So after a lot of, I noticed that a lot of Malaysian always have aims, always have pursue for wonderful meals and all these things. They just get sick so easily and die. People die at the age of 40, 50. There's no particular age that people reach in certainty and die out of health issue. Like 70 years old, you will get this and that. People just get diabetic. People just get heart issues at 30, at 35. I have fair share of health issue now, like gout or whatnot, or liver oil or whatnot, at the age of 30. And that is alarming.
Yeah.
I mean, now I don't suffer gout anymore. Hair still got a problem over there. But if I could have started earlier, this could have been prevented. I will have a healthier lifestyle. I have a more disciplined mindset. I will have a different way of viewing things, and it may solve a lot of problems which remain unsolved, especially regards to mental health, like a butterfly effect. All the things I could have been better in a position,
clearer mind
and whatnot. Though I do not look down at what I am now. I'm very happy and contented. It all started with I have a wonderful and beautiful family and very great parents, but I could have done better if I'm healthier.
So it's
Other things, I tried that same question. I wanted to study in either Oxford or Cambridge, but if you put me back 20 years time and say, Zee, how go for Oxford and Cambridge, I would not have done that. I still will be a lazy and easygoing person. So nothing else than reminding my younger self to stay healthy is more important, but it's not too late for me to realize it now. And for your audience, Zee, health is above everything else. I would advise you during Chinese New Year, 不要再讲恭喜发财了, say 身体健康, say good health to you instead of get wealth. That without health, there is no 90 over years old Warren Buffett to tell you how to invest. Or what is his partner who passed away at 90 over years old? Charlie Munger, yes. Unless you are a tech guy like Steve Jobs or Elon Musk, if you want to do investment, all these things, compounding interest is the best thing that could aid you. And to have your compounding effect to reap its fruit, you need to stay healthy as long as you can. Not just for my former self, but for all your audience. Nothing is more important than your health now. Nothing.
Wow, I love that. That's a good snippet.
Lovely.
Okay, thank you very much.
Pleasure is mine.